we're going to briefly discuss the setting of bail in a criminal case in the state of California. We're also going to discuss the consideration utilized for posting that bail. In California, the applicable code sections are Penal Code Section 1275 and 1275.1 for the conversation we'll have today. When a person is arrested on a criminal charge in the state of California, the magistrate will set the bail. When determining the amount of bail to be set, the magistrate refers to Penal Code Section 1275. 1275 provides that the magistrate consider the following four factors. Number one, and the most important for the court to consider, is the protection of the public. The number two consideration is the seriousness of the offense charged. The third consideration is any previous criminal record. Number four would be the probability of appearance at future hearings. The court will look at things like whether or not the defendant has any FTAs on their record, whether or not they've failed to show up for traffic cases, things of that nature. The last thing the court would look at, if a person is charged with a serious or violent felony, as defined by statutory authority in the state of California, if the court decides to depart below bail schedule, then they must state reasons specifically for that deviation. The bail schedule in the state of California is basically a list of all the charges and what a normal bail amount should be in those cases. So typically the court would refer to that schedule in determining the baseline for any specific charge, and then they would review those four factors. Additionally, the court can look at the consideration, the money utilized to post the bond. Under Penal Code Section 1275.1, the court can look at whether or not it believes the money utilized to post the bond has been feloniously obtained. Under 1275.1a, it states that no portion of any consideration utilized to post bond shall be feloniously obtained. Therefore, the three ways to get a 1275.1 hold on a defendant are when the police officer writes up a probable cause statement establishing facts for the court to consider as to why they believe the defendant would be utilizing feloniously obtained funds, i.e. drug money, things like that. Additionally, the prosecutor themselves can type up a PC statement. And the last way to have this type of hold or this type of finding is when the judge, by their own determination, finds probable cause for a 1275.1. They can look at the facts of the case, statements made by the defendant during the arrest, things of that nature. If a 1275.1 is placed on the defendant, then there will need to be a hearing to allow the person to post bond. At that hearing, they'd be looking at things like financial records and the person that is putting up the money. They'd explore what the relationship is and why it is that they believe that the money is now not from a felonious source. Without that hearing, there's no way to get the defendant out once the 1275.1 has been put in place. And there's two ways to actually post bond in the state of California. One is through a bail bondsman, which they typically charge 6% to 10%. That premium the person does not get back. It's just a fee for their service. The second way is to actually post the entire amount of bond yourself. All the money will then be returned to you as soon as the case is completed. Remember, if you or anyone you know has been charged with a criminal offense, please contact the law offices of Glew and Kim for a free consultation. Thank you.